Generally and problematically, it seems the conservative majority of the U.S. Supreme Court simply adjusts itself to Donald Trump, rather than requiring Donald Trump to adjust himself to the Constitution. Welcome to American News Trust. I'm still black. With case after case, the Supreme Court's response to Trump's extraordinary and unconstitutional conduct became routine, even as if the U.S. Supreme Court had become an accomplice to Donald Trump's constitutional violations, including expansive claims of executive power, attempts to push institutional boundaries in overtly criminal territory, and to say otherwise is laughable. The court's seemingly unequivocal abandonment of the rule of law in what appears to be as a result of fear is shameful, and in my opinion, the court's conduct is in actual fact a close approach to treason against the U.S. Constitution and the American people, and I'm serious about that. During the first term of Donald Trump, the Supreme Court of the United States frequently resolved major disputes in less than courageous and authoritative ways. In Trump v. Hawaii, the court upheld the administration's travel ban, emphasizing presidential authority in matters of national security. Despite evidence of racial bias, no national security issue, and the erosion of judicial checks on the president. In Trump v. Mazars, it slowed congressional efforts to obtain Trump's financial records. Critics argued it devastated the all-important and overriding aspect of constitutional congressional oversight and gave deference to the president. And in Trump v. Vance, while allowing a state grand jury subpoena to proceed, the court carefully and numbingly avoided language that would dramatically limit presidential immunity. Even when the court rejected efforts to overturn the 2020 election in Texas v. Pennsylvania, it did so tersely, without extended institutional condemnation. And as a result, the U.S. Supreme Court itself aided Trump, even worked with Trump in normalizing what was once considered extreme. That concern deepened with Trump v. United States, where the court recognized broad immunity protections for presidential official acts. Critics warned it expanded executive insulation at a moment when presidential accountability was essential. Either way, the message was clear. The court was willing to define executive power generously and recklessly, even amid unprecedented authoritarian-like conduct. This was the high point of institutional accommodation, or should I say the low point. Then came the tariff case. Reviewing sweeping trade actions taken under claims of emergency authority, the court did something notably different. Finally, it focused on law tightly on statutory limits. It scrutinized the scope of delegated power, and it signaled that even in areas that traditionally afforded deference, presidential authority is not boundless. The ruling did not attack the presidency. It did not personalize the dispute. Instead, it recentered the constitutional structure. Congress writes the laws, the executive enforces them, and the emergency powers are not blank checks. For years, the Supreme Court had appeared to adapt itself to a disruptive and unlawful president who regularly violated the Constitution. But the tariff decision suggests, at least hopefully, something else may be emerging, a required constitutional reassertion of limits. If such a trajectory, if you can call it that, continues, then despite the turbulence of the recent years, a path of normalcy may once again run through the Supreme Court. And the actual durability of that path will shape the future of the American constitutional order.